Crime in Court. My name is Heather, and this is Stream and Sarah Boone. We recently did one where she had a hearing with the judge. She got her to attempt her first attempt at lawyering, and we read through her her latest motions. Now she's got some more motions we're going to read through today. So, and there was a hearing today as well. Today, as I record this, it's August 9th, so Friday, when I post this, probably tomorrow. So, sorry. So Friday, August 9th, there was a hearing, and it was based on these motions or about these motions. The hearing itself, I watched parts of it. It's really difficult to listen because Sarah Boone, she's not on a mic, and that's been a problem in the past. But in this particular stream, for whatever reason, it is extremely difficult to hear her. And instead of struggling through that, I'm just going to read you the judge's notes and recap of the court session today. So let's get started. Please hit that like button as that helps the algorithms. And let's begin. So, Sarah Boone, as you know, she is her ninth lawyer now, and she is writing her own motions, hence the handwritten pap- uh, motions on lined paper. But she's using the same like format. She's doing it well, other than, maybe her arguments aren't the most cogent, or she might just be putting something out there and then not explaining why it relates to her case. But and that's what the thing that I said in the past is, like, she'll state a statute or some law somewhere else, but she doesn't really explain how it helps her or why it's necessary for her case. So, but other than that, like, I think she's doing good, and other than, the judge is going to have to make inferences as to what she might mean, and the other lawyer or lawyers. But all right, so this is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery. It's two boxes. Remember, this was a big deal. At first, she was like, no, no, I don't have room. And then he's like, okay, we're going to get it to you all on a flash drive. And then she's like, but wait a minute, I want the hard copy. So he was like, okay, well, whatever. She asked someone, I guess, in the prison, and they said that there is somewhere that she can store her discovery. I don't know. That was the whole thing, was that she doesn't have somewhere to put it. But let's see what she says. All right. So she wants all the former discovery. Comes now, she really wants to like look through it and see it. I think she wants to make sure she's got everything, which I don't blame her. I don't blame her. If I was representing myself, I would want to look through every hard copy piece of discovery myself. So comes now Sarah Boone, pro se indigent defendant. Struggle with that word. Indigent defendant respectfully requests from the court to lawfully receive, review, utilize the original hard copy discovery, two boxes A and B, submitted to the court by former attorney or attorneys on June 28th, 2024, for preparation of trial in her criminal case. Lawful support and valid reasons for this request made by the defendant include: one, discovery definition, exploration or examination, finding something out by search, observation, smart tablet dictionary. So that came from her dictionary, her tablet dictionary. B, the process through which attorneys acquire evidence in a case and encompasses practically everything an attorney may or must do under the rules of criminal procedure to acquire evidence. So she's giving the definition of what discovery is, which is kind of funny because neither the neither the prosecutors nor the judge need the definition of what discovery is, but hence she gets it. All right, number two, filed and posted on the clerk Clerk of Court's website by the judge on July 9th, 2024 at 9:31 a.m. The evidence control sheet states A, box of discovery, B, box of discovery. The court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. These two boxes, A and B, are the defendant's original discovery she has not seen in full to the present date, and it is her right to receive by law to fairly proceed in her defense. And I don't disagree with her. Here's some more discovery rules that the judge nor neither the judge nor the other attorneys need to know. But here we go. All right, so discovery states shall disclose to the defendant and permit to inspect, copy, test, and photograph the following information. If tangible papers or objects that were obtained or belonged to the defendant, sanctions what? Oh, she's going to talk about sanctioning the prosecution if she doesn't get things in a timely fashion. Now she wants to sanction the prosecution. I don't think that's what she's actually saying, but she's saying if she doesn't get it, then she can get, she could go for continuance, mistrial, blah, blah, blah. All these things that happen when discovery isn't disclosed in a timely manner. Number two, willful violation by counsel or a party not represented by counsel or court of an applicable discovery rule or an order issued pursuant thereto shall subject counsel. Okay, blah, blah, blah. She's just throwing in some law for the fun of it. This is not, again, like she's just throwing in quotes. The government is obligated under Brady and states, United States. So it's not like they're not giving her the discovery. She's getting it on a thumb drive. She needs to say in this motion why she needs the hard copies or why she would prefer the hard copies. It's not that difficult. Like, but she's going along and like citing every statute she can find or piece of law that she can find that sounds good about handing over discovery and even talking about sanctions. So, um, by the court here, by the court only providing digital USB discovery to be viewed solely on the laptop provided by OCCD, I don't know, and that looks like a D, I'm assuming. And restricted to select times during the day only. Motion for extended times in process. So she's trying to get longer, uh, uh, um, she's trying to get extended hours on the laptop because she's only got it from 8 to 3. Then she's got to turn it in. And that I do see her point there because that's a lot of wasted time that you could be using going through your discovery and thinking and whatnot and researching. So that is kind of prohibitive. I'll give her that. So that would be a good argument. Anyway, so by the court only providing digital USB discovery to be viewed solely on the laptop, um, it's restricted to those 8 to 3. Without the necessary hard copies, the defendant is unable to A, review, research, investigate, build her defense at any time. Numerous hours are ineffectual and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. I absolutely agree with her there. She makes a great point. So B, she's not able to write notes, remarks, interpretations, explanations, make recordings of any kind. C, transport to meetings in any location, including to the courthouse. That's true. She can't take the laptop out of the courthouse. She makes really good points here. D, she's not able to make copies for distribution or any necessary presentation in court if she doesn't have a hard copy. If one form of the defendant's discovery is unavailable, the other should be available without interruption, I think. Interruption for unrestricted full access to equally at all times be able to lawfully prepare for her trial. Both are available to be provided by the court due to the court's error of not communicating with the defendant. Sweetie, if you're asking the court for something, you shouldn't be like, due to your mistake, this mistake over here that you made, you shouldn't be doing that. Just saying. You might want to be a little more delicate. Due to the court's error of not communicating with the defendant, foremost to avoid present circumstances and the jail prior to the implementation of the order on June 28th, and after the defendant's July 8th letter questioning the location of her promised hard copy discovery, two boxes A and B, as a direct result of her extended waiting period for delivery by the court to expedite or expeditiously review, research, organize all contents, and attempt to prepare all pretrial motions as ordered by July 22nd, the defendant is now forced in this abrupt manner to only receive and be restricted to the court USB hard copies of her discovery. 6. It is an obstruction of justice to withhold the defendant's original hard copy discovery that has compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense at all available times necessary to her and on the sole independent decision of the court, as the defendant, 1, did not ask for this for or suggest this USB only option. Again, she's like, I didn't ask for this. This isn't what I wanted. Well, sweetie, in court, we're not going to do everything you want. Just saying. Number 2 was not included in any decision making, collaboration, or equal agreement for USB only format to be received. Again, you don't need to be because you're an inmate and that's the way that it needs to be done. That's the way it needs to be done. And we still don't know if she actually does have a spot or permission or whatever to bring these two boxes into her prison. I don't know if they, I mean, she only has like a small locker, she said, or a small drawer or something that she can lock. That's about it for her personal items. So I don't know what she's going to do with it. Number 3 was she was never advised by the court prior to implementation at only receiving the USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. Time, consideration, and inclusion could and should have been made on the court's behalf to free. What does that word say? Something avoid. I have no idea what that says. To avoid present disadvantaged circumstances, and the defendant would not be deprived of her due process and equal opportunities to correctly, fairly represent herself and succeed frustratingly. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court in conclusion to lawfully receive, review, utilize the original hard copy discovery, but two boxes A and B submitted to the court by the former attorneys, blah, blah, blah. By receiving the original hard copy discovery, in addition to the USB digital copies, the defendant is capable of viewing all discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully in her forced by the court position of I was waiting for that, forced by the court position of pro se and representation of self. Oath, she swears under penalty and perjury under law, blah, blah. Sarah Boone. Okay. So that's just one of a few motions that she had. All right. The next motion, and this is, we're going to get to the decisions on these things. So that's why it's important that we read through these motions. But overall, I will say she did a pretty good job on this. I mean, she seems competent enough in what she's doing, and she did a really decent job in her motion here for her discovery, other than I didn't see anywhere in there where it said that she can accept it at the prison or the jail, wherever she's being housed. I'm not sure. All right, so this Orange County, I don't know what her does she have her address on here? Um, it doesn't say. State, no. So it's Orange County, but I don't know what I'm looking for the name of the jail that she's in, but I don't it's not really that important to me. Okay. I know it's Orange County, Florida. All right. So now we move on to the motion for defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Comes now Sarah Boone, and these are shorter, so we'll fly through these next ones. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court to be unshackled, unhandcuffed, and allowed reasonable freedom in movement to function accordingly, equally, and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands and as a whole to freely, properly, successfully accomplish any task needed for. Prior to entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras, and their operators, photographers, general public, witnesses of the court, as well as vigilant armed deputies also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled and unhandcuffed. So she's telling you everybody's there to see her. So she's not going to do anything. She's not going to run because everybody's there to see her. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel. I like that she changed it here to say forfeited right to counsel as opposed to my forced pro se position by the judge. She's getting better. She's getting better. But I don't hold my hopes up for very long. We'll see. All right, so she's forfeited her right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. So she needs to be able to move around without the shackles. She has shackles on both her hands and her feet, by the way, but it appears that she's only asking for hands. Um, well, she does say unshackled on handcuffs, so maybe that means the same, but okay, she does say unshackled. Sorry. Okay, words matter. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel. Um, I read that, sorry. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive, and achievement in her criminal case rightfully, properly, and fairly. Wherefore, Sarah Boone asks for herself to be unshackled, and she swears by oath, and there you have it. All right, the next one is formal address correction. So this is a letter to the judge, and it says, Judge Cranick, I am unclear how the court had my correct address prior to you forfeiting my right to counsel, which is the sixth constitutional amendment, and forcing me to become pro se and now does not. All my pertinent correspondence is being delayed in my receipt of due in my okay. All my pertinent correspondence is being delayed in my receipt due to the court's error of sending to the wrong address. Now, all at once. Sorry, I had a cough so bad. It was awful. Okay. It's like I have to hold it till I pause it because I don't want to cough in your eardrums. So I apologize. So Sarah is unclear how the court got her address prior to forfeiting. Or they had her address and now they got it wrong. All the pertinent correspondence is being delayed in my receipt due to the court's error of sending to the wrong address now. This deters my fair and proper notice and any preparation required. Please correct immediately. Please also forward to whomever change in portals and correct in all correspondence tags or lists I am attached to and included in this or included in. By this notice, I am expecting no further hindrances or difficulties in this matter from the court's immediate attention and understanding of the importance to receive all correspondence timely and appropriately. And then she gives her address. So finally, she writes a motion for defendant's immediate address correction. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court to change, update, correct the defendant's delivery and mailing address immediately. The defendant is unclear how the court had the correct, she is just repeating herself. All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, proper notice, and preparation of any requirement contained therein. The defendant is requesting the court to please, I mean, that makes sense. If there is a deadline or something that she needs to make, she might not get it in time if her mail is not going to the right place. The defendant is requesting the court to please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, blah, 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 blah. Motion signed by, I'm not going to read through all of it. Oh, here. Please be advised also, the defendant mailed by USPS this information by formal letter to the court on August 1st to emphasize the importance of this immediate correction to be made of the court's behalf and from the court's error. Oh, so the court screwed it up. Judge, you screwed it up and you need to fix it now. Wherefore, Sarah Boone, pro se indigent, da 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 da. We're not going to read all that. So she signs that under oath. And finally, we're going to go through the notes per the court. So it states this is 8/9/2024. The state witness is sworn and testified. Um, oh, they had a state's witness. That was Corporal Gavin. All right. So, per the court comments, the court granted the defendant's motion to lawfully receive, review, utilize the original hard copy discovery. The state provided Billy Lane, representative from Prison Break Investigations, a thumb drive with the digital evidence in open court. Billy Lane to go out to the Orange County Jail today, 8/9/2024, to meet with Major Mohammed and provide him the 2 boxes of discovery, along with a thumb drive to be provided to the defendant. Defendant to provide in writing any objection she has to the digital discovery by 8/23/2024. The court heard testimony on defendant's motion for reasonable freedom in movement. After hearing testimony and arguments, the court ruled that the defendant to be hands-free but legs shackled and seated at counsel's table. She gets counsel's table, so that means in the future we should be able to hear her, hopefully. So she's going to be hands-free and at the counsel's table for any motions moving forward. Fabulous. Now we can hear her. Yay. And that is better for her that she can use her hands. Defendant to be hands-free with a stun cuff and seated at counsel's table for trial. So a stun cuff, meaning what? Hold on. I knew this was coming too. I should have researched this. Hold on. All right. So I found this. Whoops. Hold on. I found this Oh my God, dogs, can you sit the F down? Drive me crazy with the pacing. All right, sorry. So here is a stun cuff. This is what a stun cuff is.
Some prisoners may be forced to wear basically the human equivalent of a shock collar.
Does that hurt?
Yeah.
How much?
Quite a bit.
Wow, stun cuffs are strapped to your ankle or your wrist. Now, they're being used already, at least in one county in Missouri. The cops can press a button on a remote control, and that'll send a jolt to the prisoner.
Does that hurt?
It'll be used for court appearances, special court appearances, transport from other states. If we have to fly with the inmates, you can put them on them so you don't have to have them cuffed and shackled on an airplane. It's definitely a lot safer for the officers, so if the inmate wants to start fighting you.
You're basically treating them like a dog. It's like a dog collar, how you shock a dog to learn not to do naughty things. This is what we've come to in our society. Stun cuffs.
You don't
And this is like 10 years ago, I guess this video came out. So this is a news report from 10 years ago.
have to go hands-on. Everybody thinks it affects your heart and all this. It doesn't. What it does really just sends a charge through the body, which locks up your muscle.
Well, the stun cuffs do deliver, though, 80,000 volts of electricity. Authorities say that inmates would be told this before they are put on, though. Oh, gosh. I think that people are going to say, though, the potential for abuse there.
Yep.
Wow.
I completely agree.
And I don't mean, potential just potentially by law enforcement on someone. I mean, if you can buy these things, can you imagine?
Exactly.
So she has a point. And yeah, what do you think of that? Stun cuffs on your ankles or your wrists, and you get 80, what'd she say, 80,000, 8,000 volt, I don't know, whatever volts of electricity running through you. It's really ridiculous. But I guess it is what it is. She's probably going to complain about that too, but we'll see. So the defendant is to be hands-free with a stun cuff. So she's going to have this basically a shock collar, but on her ankle, and seated at counsel's table for trial. The defendant must sign a waiver for the stun cuff. So I'm forcing you to wear this. You have to wear it, and I'm forcing you to sign a waiver. I wouldn't sign the waiver, but if she wants her freedom to walk around, then she probably needs it. So the defendant provided a letter to the court identifying her concerns that the court will review and address at the 8/14 hearing. So we have a hearing next Wednesday, and hopefully she will be seated at the counsel table. She will have much better audio, and we can watch it together because this one it was just terrible audio. So I apologize. Normally I like to bring you the video and documents and everything. For you, but not today. So here are the court minutes from today's session. Comments. The court went through the mailings of documents with defendant. The defendant advised the court that she's received everything the court is mentioning. However, she still needed to finish going through her mail. The court assured her that nothing has been withheld from her. Court witnesses sworn and testified. There was the Billy Lane, who is her representative from Prison Break Investigations. He is handling both the USB drive and the hard copy evidence, and he is bringing it to her today, or the Friday, the day of this hearing. And Sergeant Chad Barnett states notice of provision of witness list was also filed in open court, but it is to be placed under seal. So there we have it. That is a wrap of what this hearing was for 8/9/2024. We will be back in court for another hearing, with Sarah Boone, and she will be at Stop it. She will be at, these dogs are driving me crazy. I gotta go. She will be at the 8/14 hearing at the counsel's table. So hopefully she will be unshackled and we can hear her. That is a big deal. to be able to hear her in these hearings. So, anyways, thank you guys so much for watching with me. Take care. Please hit the like button on your way out, and I will see you guys next time. Have a good one. Bye now.